on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this. Good morning, you're Caleb Jubert and Mr. Jubert.
Okay, buckle up. This is Judge West, and he's already warning this defendant that he doesn't even have to accept the plea deal. Translation, he's holding all the cards, and he's not afraid to fold the whole hand if he doesn't like what he sees. Let's see how Mr. Jubert handles this pressure cooker.
You've got 2 cases. Were you able to get someone hired? Speak up, please. Who'd you talk to? Speak up. Say the first one. Hand it to the bailiff. So did you talk to him or somebody talked to him for you?
Me and my mom talked to him.
So are you do you go to MHMR, Spindletop? No? What's that written on here for? You don't know? So are you working? Why not? You don't know? Where have you been looking?
I went to work. But I had to do my ID. I didn't have ID.
Do you have your ID now? Okay. If I test you this morning, you gonna have anything in your system? Have a seat, let's double check that. Mr. Jubert?
She won't take the offer, so I just said,
I'm sorry?
she refused it.
Okay, that's fine. I'll do the plea in just a minute.
So here's where it gets interesting. The judge just spent 2 minutes watching this guy squirm, and now he's about to drop the hammer. Notice the pivot. He's not asking about the weather. He's asking about the last time he smoked. This is classic courtroom cross-examination 101. Establish the lie before they even know they're trapped.
How old are you, Mr. Jubert? 18 was the last time you smoked dope. What? Last week? What made you think that was a good idea with 2 felonies pending to come be smoking marijuana? You don't know? And you're not working? Obviously, you know that's a violation, number 1, of the law and of your bond conditions, right? Speak up.
Did you catch that? I quit last week. The judge's sarcasm is so thick you could cut it with a gavel. But here's the legal reality. THC stays in your system for up to 30 days. So, quitting last week means absolutely nothing. This defendant just confessed to using while out on bond for 2 felonies. That's not just bad judgment, that's bond violation.
How do you think you're going to get a job if you're smoking marijuana? What? You quit last week? Wow, congratulations. You realize how ridiculous that sounds to say I quit last week? Mr. Jubert, I'm going to find today that obviously that is a violation of your bond conditions in each of your cases. I'm going to raise the bond in each of your case because of that violation. Let me see what they were previously at.
Now we're getting to the nuclear option. Judge West is pulling out the defendant's rap sheet like it's a horror movie script. 3 priors, no probation history, and he's still smoking? The judge is basically saying, everyone bent over backwards to give you a chance, and you spit in their face. Here's my question for you. At what point does mercy become enabling? Drop your thoughts below.
Positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case, or cases.
If I may.
Yeah.
Part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay. And I appreciate that argument that Ms. Hawkins made, but it's also...
And here comes the science. Drug patches that measure amounts, not just positive/negative. This judge isn't playing checkers. He's playing forensic chess. The defendant thinks he can game the system by quitting right before testing. The patch will show if the THC levels are dropping. If they're not, back to jail with bonds that'll make your head spin. This is what happens when you treat the courtroom like a suggestion box.
Important, and I would hope that other judges in other counties would find it just as important. I'm going to raise your bond to $15,000, and I'll go over conditions of both of the bonds in just a minute. And then in cause number 25 DCCR 1131.
Plot twist. The defendant just got caught in another lie. He knew the plea deal details, but stayed silent while his attorney spoke. Judge West's reaction is pure gold. You can't tell me what he knows. I'm talking to him. This is a masterclass in why you never sleep on your own case. The judge ends with, "You got to protect yourself." But honestly, at this point, is there anything left to protect?
Going to raise your bond in that case also to $15,000. Condition, if you make the bonds in both of those cases, is that you have to have a drug patch on at all times. You have 24 hours from the time you make a bond to get a drug patch put on. A drug patch is something that goes on your arm. Your bondsman can tell you where to get them. You have to have them changed every 2 weeks. If they test positive, then obviously I'll know you're still using marijuana and you haven't actually quit. You're going to go right back into jail with much higher bonds. I would anticipate, if you make these bonds quickly, that the first patch might be positive, but the patches are going to show me an amount, not just a positive or a negative. So if that amount is not going down, then I'm going to assume also that you're still using. Do you understand? All right, go back with the bailiff.
I don't know if I did that inadvertently, but I will honor that, and that would mean that would change it to him pleading to still the added count of an attempt R&O with dismissal of the balance of charges.
Well, he didn't know that. You didn't know that? I'm asking him. You can't tell me what he knows. I'm talking to him. You didn't know that?
Yeah, I did.
So why you ain't say that? And when I said if that's your understanding of the offer, why you say, Judge, that's not what they told me?
No.
You don't think you got to protect yourself out here?
Yeah.
You got to do better. You got to get a belt, and you got to protect yourself. You understand that?
Yeah.
Okay, so we're dismissing the assault and battery?
That is correct, Your Honor. I apologize.
No worries. As to the attempted resisting obstructing officer, how do you plead?
Yes.
And that's because you believe you're guilty of that?
Yes.
Are you sure?
Yeah.
Factual basis.